One suit for a single cause of action. What is this principle? Under Rule 2, Section 3 of the 1997 Rules of Civil Procedure, a party may not institute more than one suit for a single cause of action. In other words, one single cause of action only allows the filing of one action. Now, what is splitting a single cause of action? Splitting a single cause of action is the act of dividing a single or indivisible cause of action into several parts or claims and instituting two or more actions upon them. Splitting a single cause of action is the act of instituting two or more suits for the same cause of action. In splitting a cause of action, the pleader divides a single cause of action into two or more parts, brings a suit for one of such parts with the intent to reserve the rest for another separate action. The question is this allowed? No, this is not allowed by the rules of court. Why do you think so? The rule is intended to prevent repeated litigations between the same parties in regard to the same subject of the controversy and to protect the defendant from unnecessary vexation. As regards identity of causes of action, the test often used in determining whether causes of action are identical is to ascertain whether the same evidence which is necessary to sustain the second action would have been sufficient to authorize a recovery in the first, even if the forms or nature of the two actions be different. If the same facts or evidence would sustain both actions, the two actions are considered the same within the rule that the judgment in the former is a bar to the subsequent action. An example of splitting a cause of action is filing a separate action for specific performance and filing another action for damages, notwithstanding the fact that both arose from the same act. What is the effect of splitting a single cause of action? A single cause of action or entire claim or demand cannot be split up or divided in order to be made the subject of two or more different actions. So that is the rule. Section 4, Rule 2 of the Rules of Court expressly prohibits splitting of a single cause of action. It provides that if two or more suits are instituted on the basis of the same cause of action, the filing of one, which is litis pendentia, or a judgment upon the merits in any one, which is res judicata, is available as a ground for the dismissal of the others. Okay? What is the other implication if there is litis pendentia or res judicata? Forum shopping. Forum shopping occurs although the action seems to be different when it can be seen that there is a splitting of a cause of action. A cause of action is understood to be the delict or wrongful act or omission committed by the defendant in violation of the primary rights of the plaintiff. It is true that a single act or omission can violate various rights at the same time, as when the act constitutes juridically a violation of several separate and distinct legal obligations. However, where there is only one delict or wrong, there is but a single cause of action, regardless of the number of rights that may have been violated belonging to one person. So if the forum shopping is not considered willful and deliberate, the subsequent case shall be dismissed without prejudice on the ground of either litis pendentia or res judicata. However, if the forum shopping is willful and deliberate, both or all, if there are more than two actions, shall be dismissed with prejudice. Question: which action is to be dismissed when there is a splitting of a single cause of action? The answer lies within the discretion of the court and the prevailing circumstances of the case. Of course, the court does not take judicial cognizance of any action that is not being brought to its attention unless the same case was within the same court, right? So if in the subsequent case, the court is not notified by the other party that there was already a previous action, then the court might not dismiss the action, right? The court where the other party will file a motion to dismiss based on litis pendentia or res judicata, then that can be the court that will dismiss the action. So again, it lies within the discretion of the court and the prevailing circumstances of the case. Let's discuss the case of Chu versus Spouses Cunanan, GR number 156185, September 12, 2011. The Supreme Court held in this case that apparently the petitioners were guilty of splitting their single cause of action to enforce or rescind the deed of sale with assumption of mortgage. Splitting a single cause of action is the act of dividing a single or indivisible cause of action into several parts or claims and instituting two or more actions upon them. So the Supreme Court held that the petitioners were not at liberty to split their demand to enforce or rescind the deed of sale with assumption of mortgage and to prosecute piecemeal or present only a portion of the grounds upon which a special relief was sought under the deed of sale with assumption of mortgage, and then to leave the rest to be presented in another suit. Otherwise, there would be no end to litigation. Their splitting violated the policy against multiplicity of suits whose primary objective was to avoid unduly burdening the dockets of the courts. Their contravention of the policy merited the dismissal of the case on the ground of bar by res judicata. Now let's discuss this very interesting topic of foreclosure and collection. In this relation, it must be noted that the question of whether a cause of action is single and entire or separate is not always easy to determine, and the same must often be resolved not by the general rules but by reference to the facts and circumstances of the particular case. The true rule, therefore, is whether the entire amount arises from one and the same act or contract, which must thus be sued for in one action, or their several parts arise from distinct and different acts or contracts for which a party may maintain separate suits. Now, in loan contracts secured by a real estate mortgage, the rule is that the creditor mortgagee has a single cause of action against the debtor mortgager, that is, to recover the debt through the filing of a personal action for collection of sum of money or the institution of a real action to foreclose on the mortgage security. The two remedies are alternative, not cumulative or successive, and each remedy is complete by itself. Thus, if the creditor mortgagee opts to foreclose the real estate mortgage, he waives the action for the collection of the unpaid debt, except only for the recovery of whatever deficiency may remain in the outstanding obligation of the debtor mortgager after deducting the bid price in the public auction sale of the mortgaged properties. Accordingly, a deficiency judgment shall only issue after it is established that the mortgaged property was sold at public auction for an amount less than the outstanding obligation. In the case of Bacharach Motor versus Icaranyal, GR number L-45350, May 29, 1939. Take note of that date. This case was decided when there was still no provision about splitting a single cause of action in the rules. The Supreme Court cited several cases, in this case, illustrating no splitting of a single cause of action. In one case, it held that it is well recognized that a party cannot split a single cause of action into parts and sue on each part separately. A complaint for the recovery of personal property with damages for detention states a single cause of action which cannot be divided into an action for possession and one for damages. and if suit is brought for possession only, a subsequent action cannot be maintained to recover the damages resulting from the unlawful detention. Okay, so in another case, the Supreme Court reiterated the rule by stating that a party will not be permitted to split up a single cause of action and make it the basis of several suits, and that when a lease provides for the payment of the rent in separate installments, each installment constitutes an independent cause of action. But when, at the time of the complaint is filed, there are several installments due, all of them constitute a single cause of action and should be included in a single complaint, and if some of them are not included, they are barred. The same doctrine is stated in another case where the Supreme Court held that a party will not be permitted to split up a single cause of action and make it a basis for several suits, and that a claim for partition of real property as well as improvements constitutes a single cause of action, and a complaint for partition alone bars a subsequent complaint for the improvements. And in another case, the Supreme Court held that, as a general rule, a contract to do several things at several times is divisible in its nature so as to authorize successive actions, and a judgment recovered for a single breach of a continuing contract or covenant is no bar to a suit for a subsequent breach thereof. But where the covenant or contract is entire and the breach total, there can be only one action, and plaintiff must therein recover all his damages. What is the purpose of the rule against splitting a single cause of action? The rule against splitting a single cause of action is intended to prevent repeated litigation between the same parties in regard to the same subject of controversy. It is also intended to protect defendant from unnecessary vexation and to avoid the costs and expenses incident to numerous suits. It comes from that old maxim, nemo bedet bis vexare pro una et eadem cause, or no man shall be twice vexed for one and the same cause. And it developed certainly not as an original legal right of the defendant, but as an interposition of courts upon principles of public policy to prevent the inconvenience and hardship incident to repeated and unnecessary litigations. Okay, in this case, the Supreme Court held that for non-payment of a note secured by mortgage, the creditor has a single cause of action against the debtor. This single cause of action consists in the recovery of the credit with execution of the security. In other words, the creditor in his action may make two demands, the payment of the debt and the foreclosure of his mortgage. But both demands arise from the same cause, the non-payment of the debt, and for that reason, they constitute a single cause of action. Though the debt and the mortgage constitute separate agreements, the latter is subsidiary to the former, and both refer to one and the same obligation. Consequently, there exists only one cause of action for a single breach of that obligation. Plaintiff then, by applying the rule above stated, cannot split up his single cause of action by filing a complaint for payment of the debt and thereafter another complaint for foreclosure of the mortgage. If he does so, the filing of the first complaint will bar the subsequent complaint. By allowing the creditor to file two separate complaints simultaneously or successively, one to recover his credit and another to foreclose his mortgage, we will in effect be authorizing him plural redress for a single breach of contract at so much cost to the courts and with so much vexation and oppression to the debtor. In another case, Bank of America versus American Realty, GR number 133876, December 29, 1999. The issue in this case is whether or not the petitioner's act of filing a collection suit against the principal debtors for the recovery of the loan before foreign courts constituted a waiver of the remedy of foreclosure. Petitioner first insists that as to the issue of availability of remedies, the waiver of the remedy of foreclosure requires the concurrence of two requisites. An ordinary civil action for collection should be filed, and subsequently a final judgment be correspondingly rendered therein. According to petitioner, the mere filing of a personal action to collect the principal loan does not suffice. A final judgment must be secured and obtained in the personal action so that waiver of the remedy of foreclosure may be appreciated. To put it differently, absent any of the two requisites mentioned by the petitioner, the mortgagee creditor is deemed not to have waived the remedy of foreclosure. Do you agree? The Supreme Court disagrees. The court held that in our jurisdiction, the remedies available to the mortgage creditor are deemed alternative and not cumulative. Notably, an election of one remedy operates as a waiver of the other. For this purpose, a remedy is deemed chosen upon the filing of the suit for collection or upon the filing of the complaint in an action for foreclosure of mortgage pursuant to the provision of Rule 68 of the 1997 Rules of Civil Procedure. As to extrajudicial foreclosure, such remedy is deemed elected by the mortgage creditor upon filing of the petition not with any court of justice but with the office of the sheriff of the province where the sale is to be made, in accordance with the provisions of Act No. 3135 as amended. So there is no need for a judgment. The mere act of filing an action is already considered an election of that remedy. The Supreme Court held that in the case at bar, petitioner only has one cause of action, which is non-payment of the debt. Nevertheless, alternative remedies are available for its enjoyment and exercise. Petitioner then may opt to exercise only one of the two remedies so as not to violate the rule against splitting a cause of action. We hold that petitioner, by the expediency of filing four civil suits before foreign courts, necessarily abandoned the remedy to foreclose the real estate mortgages constituted over the properties of third-party mortgager and herein private respondent. Okay? Moreover, by filing the four civil actions and by eventually foreclosing extrajudicially the mortgages, petitioner, in effect, transgressed the rules against splitting a cause of action well enshrined in jurisprudence and our statute books. Notably, it is not the nature of the redress which is crucial, but the efficacy of the remedy chosen in addressing the creditor's cause. Hence, a suit brought before a foreign court having competence and jurisdiction to entertain the action is deemed, for this purpose, to be within the contemplation of the remedy available to the mortgagee creditor. This pronouncement would best serve the interest of justice and fair play, and further discourage the noxious practice of splitting up a loan cause of action. In the case of Marilag versus Martinez, GR number 201892, July 22, 2015, the Supreme Court held that records show that petitioner, as creditor mortgagee, instituted an action for judicial foreclosure pursuant to the provisions of Rule 68 of the Rules of Court in order to recover on the debt. In light of the foregoing discussion, the availment of such remedy bars recourse to the subsequent filing of a personal action for collection of the same debt, in this case, under the principle of litis pendentia, considering that the foreclosure case only remains pending as it was not shown to have attained finality. Petitioner's contention that the judicial foreclosure and collection cases enforce independent rights must therefore fail because the deed of real estate mortgage and the subject promissory note both refer to one and the same obligation, that is, the loan obligation. As such, there exists only one cause of action for a single breach of that obligation. Petitioner cannot split her cause of action on the unpaid loan obligation by filing a petition for the judicial foreclosure of the real estate mortgage covering the said loan, and thereafter a personal action for the collection of the unpaid balance of said obligation not comprising a deficiency arising from foreclosure without violating the prescription against splitting a single cause of action where the ground for dismissal is either res judicata or litis pendentia, as in this case. In another case, Spouses Yap versus First E-Bank Corporation, GR number 169889, September 29, 2009. The Supreme Court held that so as not to create any misunderstanding, however, the point should be underscored that the creditor's obvious purpose when it forecloses on mortgage property is to obtain payment for a loan which the debtor is unable or unjustifiably refuses to pay. The rationale is the same if the creditor opts to sue the debtor for collection. Thus, it is but logical that a creditor who obtains a personal judgment against the debtor on a loan waives his right to foreclose on the mortgage securing the loan. Otherwise, the creditor becomes guilty of splitting a single cause of action for the debtor's inability or unjustified refusal to pay his debt. Nemo debet bis vexare pro una et eadem causa. No man shall be twice vexed for one and the same cause.